All right, what's up, y'all? Welcome to Just Facts, presented by Defense Diaries. Man, just no rest for the weary. So another huge filing today. I'm waiting on Allie to join me. I invited her. She's not here yet. She will be imminently. So as you guys know, I mean, this is just like a constant back and forth. At this point, it's war. As we know, Rosie and Baldwin either withdrew or didn't withdraw. It's hard to know. All right, let's go. There she is. So then Rosie, was obviously had made some kind of promise back in chambers after Baldwin had orally withdrawn. Gull accepted that. Rosie said, you know what? I'm going to hold off. I want to put something in writing. Gull said, okay. Rosie then, I think the following Tuesday or Wednesday, we all remember, he filed his particular, his motion. He declared himself that he was still Richard Allen's counsel. And then on top of that, he filed a motion to disqualify Gull. He lays out a lot, I mean, in that particular motion to DQ, really basically in both documents, he laid out quite a bit in terms of what went on back in chambers. Now, I was sitting there in the courtroom watching everything happen in terms of a lot of people running back and forth. I mean, you could sense that something was going on in that courtroom, having been in that almost identical situation, Alice and I, with the Garcia case in terms of removal and all kinds of stuff. You could sense that something was happening. You could sense that when Gull came out on the stand or out on the bench that something didn't seem right. I'm not going to try to be a body language expert. People have all been like watching that video of her, the short hearing that I drove 8 hours total for 5 minutes, which, whatever, tough for me. Right. But you could sense that something was off. So we then come to find out that Brad Rosie not only filed for, declaring that he was still Richard Allen's counsel and then moving to DQ Gull, but he also, which I thought was most interesting and telling, was the fact that he had asked for, he requested the recipe for the transcript of everything that went down there. So that told me two things, which were critical. One, that there was going to be a transcript, that it was on the record what happened back in chambers. And two, more importantly, is that there's an audio recording of it. And the reason that an audio recording, I think, is critical in this particular situation, where a transcript will not give the full picture of what happened back there, is tone and tenor. Always. It's like sending text messages to somebody. You can't tell context, tone, or tenor from a text message. I always, like, if Allie and I are in an argument on text, I'm like, I'm not doing this via text. You can't tell like what my tone or tenor is. You know what I mean? It's the same thing here. If Rosie and Gull are going at it, screaming back and forth to each other, we should know that, because it matters. Did Gull have a sense that Rosie was not happy about this? Well, we're going to be able to tell, or we wouldn't be able to tell from a transcript because it's just words. we would be able to tell from the audio. So that was super interesting. And then the hits just keep on coming. All right. And I'm giving you guys a quick, like, if you're following the case, I think that you know what's going on. If you don't, I'm going to try to catch you up. And that's what I'm doing here. So then after those are filed, within a few hours, Judge Gull then pounds an order out. Brad Rosie has withdrawn from the matter. Andrew Baldwin has withdrawn from the matter. And you know what? Because they've withdrawn, their pleadings are stricken because they're not attorney of record, which, frankly, it's her ability to do that as the judge. Okay. What she also does, though, which is going to be with the focus of the thing that was filed today, which is it's called a verified petition for a writ of mandamus and prohibition. All right. And we're going to get to that. But what she also does is she instructs the circuit clerk, who is an elected official, who is not part of the judicial, but instead the executive branch of the government, to remove from the docket everything that was filed by Rosie. Okay. The problem with that is that is the record. That is the court record. She can 100% write an order and say basically what she did, that in my estimation, both of these gentlemen have been withdrawn from the case. They're no longer Richard Allen's attorney of counsel or attorney of record, and therefore they have absolutely no authority to be filing anything on this case. I'm striking the pleadings, and I will not in any way, shape, or form be addressing them. That's completely okay for her to do. She's the judge on the matter. She's the law of the case. What she can't do, and what's argued in this verified petition, is that she cannot tell the circuit clerk to remove documents from the actual court record. Allison, why does a court record matter in terms of an appellate record?
Well, you can't even have your appeal heard or even get your appeal docketed without the orders being of record that you're trying to appeal from and the pleadings leading up to those orders existing. And you have to provide the appellate court with the record. It's the duty of the moving party.
Right. So
did that answer your question?
Yeah, it did. It's not so much me.
I know your question for the people, on behalf of the people.
Exactly. So what happens after that is that so Rosie had thrown his hat back in the ring. All right. But Baldwin was kind of just sitting back. So after Judge Gull prepares that order, blasts it out, basically says, you know, I ain't having it. I don't want to hear from y'all. You're done. You're dead to me. That type of thing. Then we get David Hennessy, who again is the attorney that offered his services to Andrew Baldwin on the 19th, back when I was in court, when this all went down. And he had prepared like a 4-page memo. And he was basically saying, look, this thing was this, you know, like at that point they were saying, look, this wasn't my client disseminating anything. The records were stolen from his office by somebody that he trusted. He was, what was the word? It's so good. I can't believe I can't remember it. Snookered. Thank you. So yeah, he was snookered. He was, you know, by this guy who was taking all the documents. And it sounds like to me, I didn't get the impression that he actually got physical copies of the records. I think that he took pictures, because typically this kind of stuff is going to be on a thumb drive or a hard drive. So it would have been pictures from his computer, Baldwin's computer, which leaves you to the question, how did this guy know? Like, I'm assuming that Baldwin's computer is password protected, unless he's like an old man like me and like puts like a yellow Post-it with, you know, your Post-it or your password like written on the Post-it right there near the computer so you can log on. You know, I mean, that's what old people do, you know, but I don't know if that's what he got. I don't know if he actually got physical copies and made photocopies. I mean, those are things that we don't know because it never went to hearing. We may never know. But it's interesting. So at any rate, fast forward. So after Rosie's thing happened, after Gull files her order, we then get Hennessy comes back and he says, you know what? Here's the deal. Just like Brad, Rosie, Andrew Baldwin is withdrawing his withdrawal as well. He still considers himself to be counsel for Richard Allen. That was coercive. Everything that happened back in Chambers, it was a Hobson's choice. And those that don't know what a Hobson's choice is, it basically means no choice at all. You're left with an untenable situation in one hand and then a choice where that choice is really your only choice. So when she says it, look, I'm gonna fleece you guys publicly. It's going to be a public shaming, and you can avoid that. Simple. I got a simple way for you to avoid it. Just withdraw, and we won't have to go to hearing. I won't have to out you guys for everything, And then there's this letter of everything that went down. All right, so that leads us to I'm sitting here getting ready to drive to Delphi tonight, still not knowing if this matter is going to be up tomorrow. Gull, but when we get to it, Allison will help decipher it for us. So I'm going to go first to the verified petition. And then Allison has really been urging me not to read all of it. So I'm going to try to kind of skim through it and give you guys the heart of the petition. Because I think if we can do that, then I think we'll be in good shape. All right. So
it just doesn't seem that interesting to me because they, relied on the public record.
I think it's super, super interesting.
I mean, it's definitely interesting, but not like all of the entire.
Yeah, no. And look, before we go into this, I just want to be clear to y'all. This was not filed by David Hennessy. This was not filed by Brad Rosie. This was not filed by Andrew Baldwin. This was not filed by Scremmins. And this was not filed by whatever the other guy's name is, Liberto or Librato, whatever his name is. It was filed by 3 concerned citizen attorneys from the state of Indiana, who I'm going to give full faith and credit to right now, because they did the people's work. These 3 attorneys, Maggie L. Smith from Frost Brown Todd LLP in Indy, Kara S. Winky, who I tweeted at today, thanking her for her contribution, and Jesse A. Cook. So these are attorneys that are representing basically the people here, because what the thrust of this particular petition isn't relating to the inner workings of what's going on in the case. They're not concerning themselves with the withdrawals or non-withdrawals. Who's the lawyer?
So now I'm confused. Are they filing it on behalf of Richard Allen?
So there's your caption. State of Indiana on the relation of Richard Allen, relator, versus Carroll County Circuit Clerk and the Honorable Francis J. Gull, Special Judge. So, I mean, maybe you do want me to read the whole thing.
Well, maybe. I mean, let's just start by letting the people know that a writ of mandamus is a civil action where you're sort of expediting something up to the Supreme Court saying, like, this needs to happen now. I've got no other form of relief. So something like compelling a judge to do something that they are required to do, that they have a duty to do, that they're refusing to do, would fall under that. I don't know if you want me to get into more detail right now, but
no, let's I'm gonna pick and choose. I think,
but I sort of am confused about if so. As the relator, they can do it on their own accord.
Apparently, I mean, if they can't, what's going to happen is the Indiana Supreme Court is going to say sorry. But it seems to have more teeth than an amicus brief, which is just in support of. So
no, for sure, it's definitely they're filing the petition.
All right, so I am going to read the beginning of the petition. Okay, the court has expressly declared that there are, quote, there are strong societal reasons for allowing public access to court records, and denial of that public access could compromise the judiciary's role in society, inhibit accountability, and endanger safety, end quote. So they pulled that from the commentary of the Indiana Access to Court Records. All right. If there ever was a time where this court's unequivocal mandate for public access to court records was critical, it's in the present instance. Now, I tweeted the exact same sentiment. I can't think of another case wherein transparency in what's being filed and what's going on transactionally and procedurally in this case needs to be out for the public to look at. It's transparency is the entire reason, and accountability is why we have access to public records in cases like this. We want to make sure that judges and prosecutors aren't being shady, or defense attorneys, whoever, whatever the case may be. We need to be able to see the documents. So this is one of the most high-profile cases this state has ever seen, and for many Hoosiers, this case marks the first time they have followed the workings of an Indiana court. And they're talking about the world, all of us that are following this case. They're doing this. They filed this on our behalf. So thank you, if any of you happen to be watching the live. Yet at virtually every turn, the access to court record rules, and most recently, the Indiana trial rules, have been violated, and Hoosiers and the media, both local and national, have been left on the outside looking in. Instead of the sunshine that public access is supposed to provide, the public and the media have been left in the dark. A writ of mandamus and prohibition is needed here because the trial court has a clear and absolute duty to follow the court's mandates. And they're talking about this court, the Supreme Court of Indiana, ensuring public access to court records, but has failed to perform the duty repeatedly. All right. So this is basically, babe, what do you think? Should I go through the facts? I think I should go through the facts.
Yeah.
I think what we do is we go through, because the brief is, I think, 17 pages long, and the brief was filed attached to this, and it supplies the case law. If y'all, that's typically how it's done. There's going to be a petition where they're laying out the facts, and then they say, here you go, judge. Here's all the case law that supports our argument. Okay. So, and that's what happened here today. So these are the facts supporting the petition. Last spring, the defendant, relator Richard Allen, filed a series of court records in this case and marked everything as public documents, original action or proceedings. That is the citation. So whenever you see that in a document, they're citing the record. Okay. Paragraph 2, but someone within the court system, sua sponte, someone being the judge, whenever you hear the word sua sponte, and if you've been following my texts and my battles with Brett, online, I keep talking about where is the sua sponte motion to DQ filed by the judge. Sua sponte is Latin for on her own accord, on the court's own motion. All right. Changed all of Allen's files to confidential, whatever that means. It's not under seal. So I don't know what confidential means. Do you know what confidential means? Obviously I know what the word means, but I'm talking about in the context of legal proceedings. What does the word confidential mean? Have you seen that? Let me ask you that. Like on the R. Kelly case, which was a sealed case, did you see the word confidential, or was everything just under seal?
Well, initially the entire file was under seal, but now that the courts have said you can't just seal an entire file, you have to elect, just like you do when we do our e-filings, confidential or non-confidential. To choose confidential, it's got to comply with whatever that state's requirements are for something to be deemed confidential. Might lose permission ahead of time. It depends.
Okay. Now, yeah, I've never seen confidential in relation to court filings. So like, these aren't classified documents. These aren't government secrets. You know what I mean? It's a public case, and they're using terms that I don't typically see in the law. That's all I'm saying. Okay. So, and excluded all of them from public access without informing Allen. And then for the next 3 months, more than 125 separate documents were excluded from public access. They cite the record. On June 28, 2023, the trial court explained that all of those documents had been excluded from public access to, quote, comply with the court order dated December 2, 2022, which prohibits public comment, commonly referred to as the gag order. Even though, and this is the thing that I'm always trying to explain to people so they understand that there's a difference between a gag order and documents in a case being sealed. They're entirely two different things. And gag orders only govern extrajudicial comments, not court filings. Now, Allison, you were an absolute expert from personal experience on extrajudicial comments. What is that?
Anything that's said outside of court.
Right. And typically to the media.
Right. I mean, right.
Right.
They're usually using it to refer to like the media, but technically it could be if I, told the paper guy.
That's the media.
No, I meant like the milk delivery guy.
Oh, you mean the paper person.
The paper delivery kid.
All right. So a gag order relates to the parties involved in the case, lawyers, judges, bailiffs, cops, everybody. They can't talk to the press about the facts of the case. That's what a gag order is. A seal order is where all the documents in the case are sealed. But as you'll see from this particular document, there's rules for that. You can't just seal things without giving an actual reason. And you know why? Because of the Constitution. That glorious, glorious document, the Constitution, which protects our rights, the citizens' rights, against the government, from the judge, from the court, from the prosecutors, from the cops. That's what the Constitution protects us from. And you know who defends the Constitution, right?
I wonder who.
Defense attorneys, not prosecutors, not cops, defense attorneys. So paragraph 4, the trial court then allowed the parties to agree, in quotes, to exclude the entirety of certain records from public access, both of which are prohibited by the access to court record rules. All right. Now, if you've been following this case from the beginning, you will recall that when the PCA and the arrest first took place, so they walk in, Liggett walks in with the probable cause affidavit for the arrest, says, here you go, Judge. This is what we got on him. We think it's enough. I hope you do too. Judge looks at it. Looks thin, but I'm going to sign it anyway. I don't know if the judge said that he should have, but signs it anyway. Alan gets arrested. We're all like, oh my God, look, wow. And as an attorney, I'm on the docket and I'm like, well, where's the PCA? Like, why am I not seeing the PCA? I come to find out that Gull has sealed it. It's under seal. I can't see so I'm like, wow, man, there must be some incredible, there are specific rules in terms of sealing documents. Things such as you're concerned about the safety of officers or witnesses. It's got to be something very dire for the court to say, you know what? I don't think the public's ready to handle this truth right now, or this alleged truth right now. So I'm going to go ahead and seal it. So it took months for her to unseal it. And then when she unseals it, I'm like, what? Why was this thing sealed? I'm like, as a matter of course, they redact witnesses' names in PCAs and documents. That happens. So there was nothing in that document that required that thing to be sealed. Like, those facts in that PCA were no more shocking than any other homicide.
Was it before he was arrested or after?
No, he was arrested. That was for the PCA for the arrest warrant. So
it was sealed even after his arrest. Yeah, that's right.
Right. So as to the other improperly excluded court records, rather than making them public on the CCS, which is Carroll County's docketing system, something the clerks do all the time, the trial court created a link at, and there's the link for you, and uploaded a zip drive containing 118 documents. Now, you remember the big doc drop, right, babe? The dump?
Of course.
Remember that day?
Remember.
And what they're going to say from personal experience with trying to get those documents. Now, granted, I am an old, incompetent tech guy, and it was very difficult. I had a hard time accessing the documents. Thank God my wife is brilliant. And she's like, okay, here, moron. Here's the documents. I'll put them in Dropbox. I'll put them in a nice little folder for you. Here you go, honey. And she patted me on the head. I'm like, oh, thanks, babe. So that, but apparently a lot of other people were having the same problems that I was. All right. So, but the file names of these 118 documents have no identifying information. Now, that was true, right, Allison? It was very difficult to tell what was what.
Yeah, I mean, I had to read them. Most of them were unidentified. Yeah.
Right. Like, and you had to open up the document and then try to figure out what it was by reading the caption. All right. They had no clear identifying information to enable somebody to recognize what the document actually is. None of the exhibits to a particular filing are anywhere near the actual filings that they should go with. And the file date for every document is 6/27/2023. That's a big point. When you have documents that are filed in a court case, the dates are critical. Absolutely critical. If there are arguments being made that statutes were blown or dates were blown in terms of things when they were supposed to have been filed, and now they're just saying that everything was filed on 6/27/23, which was actually just the date that they opened them up to the public, that's a real problem for the appellate court. And now explain how the appellate court works. And I'm talking about how they rely solely on the record. They aren't calling the lawyers. They're not talking to the defendant. They're not talking to the judge. And I'm talking about the appellate court. They are relying on the record, right?
Right. As soon as you file your appeal, the first step is transmission of the record on appeal, which the defendant has to facilitate and put in motion, and then the clerk has to do, because other than that, the appellate court has no way to access the lower court's, records and see anything that's happened.
Right.
That's why I said earlier that it's the duty of the person filing the appeal to make sure that the record is transmitted and everything they want transmitted is included in the record.
For sure. So in my thing with this about the transparency and accountability is, in a case where the only thing that any of us care about or care most about is justice for Abby and Libby, it's becoming, it's murked under. It's getting drowned in a swamp of the morass, and people that are wanting to say, oh, well, I'm blaming the defense attorneys. I'm sorry, but that's just incorrect. When you look at it, like I keep saying it, the judge's docket on this case speaks for itself. I mean, y'all could pull it up. And as a matter of fact, there's a 229-page document that was attached where they put the whole thing on blast. And when I'm going to get to that thing, it's the record of proceedings. And it is epic. It's got her docket or the lack thereof. As far as Judge Gull is concerned, and I don't know the woman, I've never practiced in front of her. It was my hope that she was up to the task of handling a case of this magnitude. And when you have a case where the eyes of the world,
She's cracked.
I mean, I don't know. Like, I'm not going to besmirch a judge other than factually of what I know and what I've seen in terms of how she's handled this case and this docket thus far.
Right. I'm speaking on the docket. It seems
well, yeah, and that's all we can go by. You know what I mean? It's like that's all we can go by. We as if we were the appellate court. It's a mess. It's got gaping holes. And when you have that going on, it's a real problem for a case that if Richard Allen is in fact convicted and he tries to appeal it, you're talking about an appellate court that's going to be sitting there scratching their head, trying to go through this record, saying, what the hell is going on? I see that motions are filed and no hearing dates are set. I see that this judge is striking things from the record in their entirety, that we can't even see the documents. I see that the judge is removing documents and placing them under seal when the case is not under seal. It's not the way it's supposed to be done, kids. It's just not. Because the CCS, and again, that is the docketing system for Carroll County, in this case still has every one of the 118 court records excluded from public access, which means if you were to go on the docket today and try to access any of the filings, any of those 118 filings, you would not be able to do so. You would have to, and they're going to explain that what you would have to do in order for us, the public, to be able to access these documents, which we have a right to see. Okay. And this isn't about graphic pictures, and this is about court filings, documents that are public record. That's what this is about. This isn't about gratuitous things. This is about records that were filed, motions, petitions, everything that's been filed in the case, so that we know as a society what's going on in this case, instead of having to try to read it through the tea leaves. So the only way a member of the public can access anything in this case is if they somehow know how to read the June 28th, 2023 court order. See the link embedded therein, which is in this particular document, and then proceed to open each of the 118 documents until they find the filing they were looking for, which again relates back to the fact that they didn't, when they dropped the docs, they didn't say what the document is. Like if you look on a normal docket for any criminal case, you're going to see motion to suppress filed by the defendant on such a date. And then you click on it, typically the document opens up. I mean, some counties have it where they only have access for attorneys to be able to get the full docket in terms of being able to get the documents themselves, but they always tell you exactly what was filed and exactly when it was filed. Paragraph 8, more recently, the trial court has begun sua sponte, again on its own motion, removing and excluding filed documents from the CCS altogether. For example, on September 18th, 2023, Allen made what is known as a Franks filing, wherein a defendant seeks to present evidence that the officer who prepared the probable cause affidavit misled the court to believe probable cause ever existed. See Franks v. Delaware. Allen filed 3 documents with this Franks filing: a motion, the controversial memorandum in support of, and an exhibit list, and made all of them publicly accessible, which they were supposed to. You know, like people have been giving me grief because they were asking, would you have filed that memo publicly? Of course. The case isn't sealed. It's a filing. Now, do I have some issues with everything they contained in there? Yeah, I do. But not because of the fact that they talk about Odinism, and because I think that that's insane. I don't like it because it buried the fact that there's alternate suspects and there seems to be a real Franks issue that got like buried in it. That's the problem I had with it. Yes, I didn't want to see them have to put in like the Richard Allen and all the graphic crime scene stuff. But I mean, that wasn't my real issue with it. And yes, it should have been filed publicly. We as a society have the right to view these filings. So, but someone, paragraph 11, within the court, someone within the court has since removed or excluded the Franks memorandum from the CCS altogether. Now, we remember how that went down because Allison had emailed the county clerk at Carroll County and said, hey, can you email us the filings? She's like, sure. Shot them out to us. We had them. Within 3 hours, Gull orders them to all be sealed. So they vanish off the docket so no one can see them. So paragraph 12. Likewise, after the trial court attempted to force Allen's counsel attorneys Andrew Baldwin and Brad Rosie to withdraw under duress and in direct conflict with Allen's express declaration that he wanted only attorneys Baldwin and Rosie to represent him. Allen instructed his counsel to make certain filings on his behalf. And on October 27, 2023, however, the trial court ordered the clerk to remove, not seal, not hide, but to pull him from the docket. Remove all of Allen's filings from both the CCS and the electronic case file. All right, so this next part gets into all kind of the rules that the judge has to follow. These are rules handed down by the Indiana Supreme Court, and they are the rules of the land in Indiana, and everybody that is on the bench has to follow these rules. And so it basically says that in order, I want to try to figure out what to read per Allison's instructions.
Yeah, and by the way, while you're doing that, the Supreme Court already issued an order.
Wait, I know. You're jumping way ahead. Do you want me to throw that up?
No, you can do what you're doing now.
Okay. Yeah, I know. I got it. Okay, so I'm going to skip to paragraph 18 here. Rule 2A of the Rules of Procedure for Original Actions contain a condition precedent requiring that the subject matter of the original action must be raised and ruled upon by the trial court prior to an original action. Now, this is where they are trying to address what, Al?
I'm sorry, I was reading other stuff.
All right, so it's cool. So what they're trying to do is they're trying to get ahead of the game because they're anticipating that the Supreme Court is going to say, okay, well, sorry, guys, you didn't follow the rules of filing this petition, which is that there has to be a ruling, an original action where it stems from. Okay. So and then they don't even get to the issues at hand because they're rejecting the filing based on the fact that they didn't follow a baseline rule. Okay. So that's what they're saying there. There's rules that you have to follow in order to get something in front of the Indiana Supreme Court. And so what they're trying to do is get ahead of that, anticipating that the Supreme Court's going to be looking at it and say, well, there's no original action here. I don't even know why this is on my desk. Get the clerk, come in. Why did you put this on my, you know what I mean? So they're trying to get ahead of it. And they say doing so in this case, however, is an impossibility because the trial court refuses to accept any filings made by the only attorneys Allen has authorized to represent him in the trial court below. And that's Rosie and Baldwin, and has ordered the clerk to remove anything new that they file. So what they're saying is, how can we have an original action wherein the trial court ruled on it when she has erased them off the face of the earth? Okay. Accordingly, there is an impossibility of performance of the condition precedent, and the facts and posture of this case create extraordinary circumstances that warrant this court excusing that condition precedent. And they have a footnote. Allen believes that this is analogous to the condition precedent in the appellate court rules that a motion for a stay pending appeal may not be filed with the appellate court, quote, unless a motion for stay was filed and denied by the trial court. This condition precedent may be excused, however, upon a showing of extraordinary circumstances.
Which apparently they accepted this as that since they've taken action.
I mean, at least on the front end. I mean, they accepted the filing, and
I mean that gets them over that hump right there, though, because if
all right, so you're almost forcing my hand to just throw up this order.
No, go ahead.
I don't mind.
It's
all right. We'll wait on it for just a second. But before we go into the brief or whatever, we'll do you want me to quit asking you questions so you can review? Like Allison was doing actual work on one of our cases when I started saying, I need you to help me. Are you gonna, so she was doing other things while I was reading this. So in fairness to Allison, it's not fair for me.
I was trying to read about when because the way it's titled, with it being the state of Indiana on relation of Richard Allen, because it does say that the state would be the appropriate plaintiff. And then I was looking at the ways where a third party can basically act as the state, sort of.
Right. Well, I mean, they're bringing the county. They're bringing this against the county and the judge because they're the ones that are violating state law. So
right.
All right. So these are the grounds for the writ of mandamus and prohibition. A writ of mandamus and prohibition is appropriate and warranted in this case because the trial court has failed to perform the, quote, clear and absolute and imperative duty imposed by the access to court records rules and the trial rules. And they cite a case. Paragraph 2, writs are issued by this court in a wide variety of circumstances, such as to enforce court rules, effectuate the disqualification of a trial court, order a criminal defendant to be released from jail on his own recog, and address a trials court failure to adhere to statutory mandates. And that has a footnote. And I'm not going to read it because it's basically just case citations. Okay. Writs of mandamus and prohibition have also been issued to address matters affecting, quote, the public trust in the integrity of the judicial process, which is what I keep talking about with transparency and accountability. We have to be able to trust what the hell is going on in courts of law. It matters. I don't care if you're a defendant, if you've never been arrested, it doesn't matter. Our country is the backbone of our country, and the judicial system relies on us being able to examine what is going on in those courthouses all across the country. We can't have it happening secretly. Do you imagine that? It'd be a nightmare. Absolute nightmare. Oh, well, yeah, you know, people are ending up in prison. We have no idea why.
So according to this, that the judge is continuing to remove them, like they've still been trying to file stuff?
Well, I mean, as recently as Rosie's pleading.
Well, the motion says the trial court continues, or the brief, the trial court continues to violate these absolute duties by improperly removing documents from the CCS. So it seemed like maybe it was ongoing.
I mean, I consider like 3 days ago ongoing. You know what I mean? I don't know. What I don't know is if she also bounced Hennessy's Baldwin motion. I mean, right. I guess she might have. I don't know if anybody out there in the chats know. I mean, I got Yellow Jacket and Sleuthy out there, who are two of my absolute go-tos in terms of keeping me in the loop and getting documents to me like before I even open my eyes. Like, wake up! Got stuff going on. So yeah, check that. Somebody check the docket and see if there's any record of Hennessy's filing with regards to Baldwin, and somebody put it in the chat. All right. So then we've got paragraph 24. The trial rules mandate the trial court clerk, quote, shall maintain a sequential record of the judicial events in such a proceeding, and the CCS must reflect all trial court events, which include any and all filings. That relates back to, again, when we think about the 118 documents that were dropped, and they stuck a singular date for all of those documents. So if you're reading through the docket, it appears that everything was filed on whatever that June date was, June 23rd, 2023, or 27th, whatever it was. So in addition, Indiana court records are to be open to and accessible by the public, and that is ACR rules 1, 4A, and B. Paragraph 26, unless an entire case is excluded from public access, which is not at issue here. This case is not under seal. There are only two ways a court record may be excluded. One, if it falls within ARC or ACR 5B or C, in which case it is excluded as a matter of right, or two, under extraordinary circumstances. And those must exist, and all of the requirements of ACR 6 are met. Okay, and that's ACR rules 4, 5, and 6. That's going back to when they decided to seal the PCA. There had to have been extraordinary circumstances in order for them to be able to do that, to stop us from being able to see why this guy was arrested. Okay, and they did not exist. I can tell you that flat out. Like I said, when I read that thing, I'm like, what? Why was this under seal? I don't know. 28, and unless everything in the document can be properly excluded from public access, there must be a public access version and a non-public, I think the Scout Home, and must be a public access version and a non-public access version of the document. The public access version has the confidential information redacted, but all of the non-confidential information in the document must still be publicly available. So meaning things like exhibits, which may have, gratuitous violence, or may have, say, for instance, crime scene photos, anything like that. The document itself still has to be public, but those types of things they can put under seal and not allow them to be publicly accessed. Moreover, every confidential record must be accompanied by an ACR form identifying the specific Rule 5 grounds upon which the exclusion is based. Okay, simply filing the document and locking it does not satisfy the notice requirement. A person looking at the case will see that a document is excluded in its entirety from the court record, and the person must also see the ACR form stating what document was excluded and why. Now, the primary drafter of this particular document, I think, was Maggie Smith. Now, I saw a tweet from one of the other contributors, and she said that unequivocally Maggie Smith is the all-knowing wizard of court rules in the state of Indiana, that she is the go-to. Like she wrote the book type lawyer. All right. So she knows what she's talking about. She knows these rules like the back of her hand.
Yeah, I would have had to spend forever researching the rules just to write it.
Right.
Because those are rules, obviously, that we don't come, cross paths with on the regular. Or
exactly. I mean, this is incredibly unusual for this to be going on in any case. I mean, to me, this is I am absolutely just mind blown by this case every day in the last 2 months. Every single day. There's no rest. I can't rest because I'm so just dug in on this case and for justice for the girls. And it's so murky right now. It's so murky. I mean, I don't even know if there's court tomorrow. I don't know what's going to go on in court tomorrow. Is Richard Allen going to be transported there? And he's got 2 guys he doesn't want representing him. And because he's indigent, he has no choice. He's stuck with 2 guys that she's stuck from her home county that have all kinds of issues. I mean, you got one guy going on TV talking about how strong the PCA is against his now client publicly. And you got another guy who has been dinged by the disciplinary committee and, is just coming off that. Doesn't mean he's not a good lawyer. However, now I've heard that Judge Gull's daughter, Christina, happens to be a prosecutor, and that this other guy is constantly in court with her. I mean, it seems very incestual. It seems very scary if I'm Richard Allen. If I have somebody getting that word to me, and who knows if anybody's getting any word to him because he's jailed in a prison. I mean, if people don't see a problem with that, I don't know what to tell you, because there's a problem with it. The trial court here has repeatedly failed to perform the clear and absolute and imperative duty imposed by these rules when it's sua sponte, again on its own motion, the court, Judge Gull, removed or excluded the Franks memorandum and ordered the clerk to remove all of Allen's most recent filings from both the CCS and the electronic case file. Even if a trial court believes that these filings are improper or unauthorized, that does not justify the removal or exclusion of the court records from the CCS altogether. Instead, the trial court may do what I was talking about earlier, may enter an order declaring that a court record is improper or unauthorized, and may inform the parties and the public that it will not review or consider such filings. But a trial court cannot order those records removed or excluded from public access altogether. In addition, after the trial court recognized that the 118 court records had been improperly excluded from public access, including court records that had been marked public when filed, and then sua sponte, on her own order, changed by the court to confidential, whatever that means. The trial court created a link, which there it is again, which contained a zip drive with all those 118 documents uploaded. But this does not satisfy the trial court's duties under the access to court record rules. Not only did the trial court allow the parties to, quote, agree, end quote, to exclude the entirety of the certain records from public access, but the zip drive does not provide meaningful public access. The file name titles of the 118 documents have no clear identifying information to let someone know, someone being us, the public, know what the document actually is. Every document has the date of 6/27/2023, and none of the exhibits to a particular filing are connected to the actual filings. That's like, for the appellate record, how are they supposed to go through the record? You're muted.
It's impossible.
Right. They can't do it. They have, like, Judge Gull has effectually destroyed Richard Allen's appellate record. That's what she's done. She has to go. She has to go. I don't know what her issue is, but she's got to go. She up and bungled this thing. It's been bungled.
It's been bungled.
Because the actual CCS in this case still has every one of the 118 documents excluded from public access without any ACR form accompanying a single one of the excluded documents, the only way a member of the public or media can access anything in this case is if they know they need to read the June 28, 2023 order, see the link embedded therein, and then proceed to open each of the 118 documents until they find the file names that they're looking for. In addition, there are still 2 documents that remain excluded and are not on the zip drive, and they do not have an ACR form, and for which an ACR Rule 6 hearing has never been held. 1, a June 20th, 2023 filing by the Carroll County Sheriff, which I would very much like to see, and 2, a July 5th, 2023 letter from a DOC inmate. 40, the writs of mandamus and prohibition are needed to ensure court records that were either removed or improperly excluded are placed back on the CCS, made public, and remain publicly accessible. And going forward, the court records may only be excluded upon compliance with the access to court record rules. Okay, so this is what they're asking for, what they want. Okay, they want, 1, mandating that the trial court reinstate the following court records as publicly accessible documents on the CCS and the electronic case file. A, Allen's September 18th, 2023 Frank's memo. B, Allen's October 25th, 2023 verified notice of continuing representation by Rosie. C, Allen's October 25, 2023 motion to DQ Gull. D, Allen's October 25, 2023 precipe for the transcript. So he has proof of what's going on back there in chambers, in secret, out of the public eye, where you got a judge just blowing hot. And then you got E, Allen's October 26, 2023 motion for a continuance. 2, prohibiting the trial court from ordering the removal of any court records filed in this case from the CCS and the electronic case file. 3, prohibiting the trial court from excluding any public access to any court records without the requirements of the access to court records rules being satisfied, including but not limited to every court record excluded from public access must be accompanied by an ACR form identifying the specific Rule 5 grounds upon which exclusion is based. If you guys don't understand what that means, and I'm not prepared to plop those up because I was trying to get this ready, but it's basically going to require the judge to state, this is why I am pulling this off the docket for public access. It's going to remain on the docket in full, but I'm not allowing the public to access it because of this. And she's got to enumerate the reasons why. Okay. And then B, unless everything in a court record can be properly excluded from public access, a public access version and a non-public access version of the document must be filed. And then 4, mandating that 118 documents on the zip drive must be made publicly accessible to the CCS itself. 5, mandating the court records referenced in the June 28, 2023 order that remain excluded from public access by agreement be made available for the public access 72 hours after the writ is issued, and unless the requirements of Rule 6 are thereafter satisfied. Okay, and then finally, mandating that the June 20th, 23 filing by the Carroll County Sheriff and the July 5th letter from a DOC inmate, quote, be made available for public access 72 hours after the writ is issued. Now, when they're talking about the writ being issued, now there was a lot of people were confused earlier, and they were like, oh, the order's already been granted. No, what they did is they included a proposed order outlining everything that they just asked for. And if the Supreme Court of Indiana agreed, then the judge would then sign off. The Indiana Supreme Court judge would sign off on the order, and then it would be an order. So that's a proposed order. It's not a fake. It's something that's done as a regular course of business in the law, where an attorney will prepare a written proposed order ahead of time and submit it with their filing. So that's all that was. All right. So that's that. That's that whole document. What do you think, Al? What do you want to look at next? You want to pop the brief up? Is there anything you want to go on in the brief?
There's a lot in the brief. I don't even know. I think it's just basically that. I mean, there's no reading this entire, 22.
Yeah, there's no way.
But they get into like that the judge, the judges, them asking to have the judge removed, and basically just establishing that she's failing to perform a clear and absolute and imperative duty imposed by law. So, and outlining different cases that they've done writs of mandamus for this type of situation.
Right.
I mean, not this exact situation, but where a judge is refusing to hear a motion that's been filed, or to, remove something that was improper. Sometimes that, with the appropriate documentation.
All right. Well, I'm going to read this. Okay. So this is on page 8 of 22. And this is interesting because this, for all those who were wondering out there, whether Richard Allen still wanted Rosie and Baldwin as his attorneys, this will be your answer, because I'm going to read you this email or this letter signed by Richard Allen. Okay. So the trial court attempts, so it's IC, the trial court attempts to effectuate the removal of Allen's chosen counsel over his objection and without his consent or approval. Now, the whole Sixth Amendment argument, whether or not an indigent client or defendant has been appointed public defender, the rule of the land for a long time was that they don't have a choice of counsel. They can't say, I don't want that public defender, I want a different one. And the trial judge can say, nah, that's your lawyer, buddy. You're stuck. Now, the question then becomes, when you have continuity that takes place, where you have a lawyer that's been representing somebody for over a year at this point and is fighting like hell on behalf of the defendant, and that defendant has formed a true client-attorney relationship with his attorney to the extent where he's like, you know what? My entire life is hanging in the balance. My life is hanging in the balance. And I don't know what y'all feel about that, but if I'm in Richard Allen's position and if I'm innocent, I don't know if Allen is. I happen to think he's innocent. I don't know. I mean, maybe they have more evidence. Maybe we'll find out at trial if there ever is going to be a trial. I mean, but I know that I shouldn't be punished because I don't have money to hire private counsel, that I can't have the counsel of my choice. Because the way the law of the land was for a long time is indigent defendants were stuck with whoever was appointed to them as a public defender, and then private counsel that was retained, they had the defendant had the ability to say, okay, well, that's my choice. I actually made that choice. I paid that lawyer to be my lawyer. So the court doesn't have the authority to strip me of my chosen counsel. And to me, that's inequitable. How is that fair? In what world is that fair? That money dictates who's going to represent you when your life is on the line. Money should never be the issue when it comes to our lives. That's my opinion on it. So in early October of 2023, counsel for Allen learned that Mitchell Westerman had surreptitiously and without authorization photographed crime scene evidence so that substantiates that he was photographing it. Now, I don't know if it was off the computer or if they had printed out and had hard copies of it, but that he, without authorization, photographed crime scene evidence in this case that was being stored in Allen's attorney, Andrew Baldwin's office, and then disseminated those photographs without Attorney Baldwin or Allen's other attorney, Brad Rosie's consent. Attorneys Rosie and Baldwin immediately informed Allen of this theft, which included in the record of proceedings, there is the email from them alerting the judge as soon as they became aware of it, of what was going on, which I'm going to get to those. I'm going to read those. Attorneys Rosie and Baldwin immediately informed Allen of this theft, and Allen unequivocally informed the trial court that he still wanted these attorneys to represent him and that their representation to date had been in his best interest. I'll try to blow this up if I can. All right. Make it so it's readable. All right. So this is to Judge Gull. Dear Judge Gull, please accept this letter as confirmation that I communicated with attorney Bradley Rosie regarding the circumstances regarding the leaking of sensitive information in the case. I am aware that images of the crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that this distribution of these documents could have on my defense. Attorney Rosie has also communicated to me that the prosecutor has requested that my attorneys be DQ'd from representing me in this case. Fascinating. That is the first thing that I have heard about who initiated the disqualification of Rosie and Baldwin. I kept asking on the docket, arguing with various people, where is the initiating petition seeking removal? Now, this is dated October 11th. So why didn't McClelland file the motion for the DQ? Why isn't that on the record? He's talking about doing it. He's threatening to do it, but then he doesn't file it. Because talking is one thing, doing something is a completely different thing. And if he does it, Richard Allen then gets proper notice that it's going on. That did not happen in this case. And due process matters in this country. And due process means that you get notice of anything that's filed against you and that will affect your ability to have a fair trial. That's the Constitution. It's what it says. So he says, I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved, one way or the other. I believe they are acting in a manner that is in my best interest. I appreciate your time and consideration in this matter. So I will consider the subject of whether or not Richard Allen believes that these two guys are acting in his best interest closed permanently.
Why are there people who don't think that?
Huh?
Are people, they think that he doesn't want them to be doing this, or they just think they're self-motivated?
Both. They think that they're self-motivated, that they just want money and fame, and they don't care about Richard Allen. This ends that argument.
Well, they could get more fame probably by just like now they can talk. Well, not about certain details, but about some things.
Yeah.
Not the evidence.
Right. So that's Richard Allen's on the record, and they put it on the record. It's on the record now. Now it's on the record, Supreme Court's docket. Richard Allen unequivocally wants Andrew Baldwin and Brad Rosie to represent him for the rest of this case. And
they attached a whole slew of documents.
That's what I'm saying. The record, the proceedings, it's a lot. Like we'd have to have a 7-hour live here. People would be falling out.
No, but on page 5, they list all the, oh, is that that's what is at the link? Oh, the zip drive.
All right, wait a second here.
Never mind, I take it back. I see.
Okay, hold on. Sleuthy Goosey sent me an email. I have to check real quick. Oh, she was alerting that I have, we all have, or at least anybody who downloaded it has McClellan's cell phone number. Thank you for that tip. I don't want to put that dude on blast. So thank you.
Downloaded what? This petition?
No, it's in the record for proceedings. Apparently, they did not redact McClellan's cell phone number off one of the documents contained therein. I'll have to be aware of that and make sure that I don't show that particular item.
Don't want to be.
I don't want to be the guy when people are calling him and saying, "What are you doing, man?" I'm not going to be that guy. I mean, I wouldn't mind calling him and having a frank discussion with him to find out what he's doing. Like what?
Well, now you got his cell phone number.
I got his cell. So, all right. Okay. So this is all kind of relatively interesting stuff. Okay. Prior to this meeting, so I want to read through this part because this is factually interesting. Like this is so the original filing, the petition for the mandamus, for the writ of mandamus, isn't getting into this stuff. The brief is. So this is kind of outlining all the mishigash that went on in this matter. Okay, so attorneys Rosie and Baldwin also immediately informed the prosecutor and the trial court of the theft. Okay, and this will be our cite to the record. Allie, mark that down for me. It's these are the emails. That's page 191 and 193. I want to be able to ask.
Nothing.
Oh yeah, I forgot. We're the only two lawyers in the world that don't have a pen in our house.
Well, because I rushed over from my desk and I even left my phone, which is usually what I can put a note. I can put a note. What'd you tell me to note?
I want to give you pages from the record that we're going to go to after this.
Okay.
That I want to access. It's interesting documents that we all want to look at. Okay, so it's pages 191, 193. This is the email from Rosie to Gull informing her of the theft of the documents. Okay, the trial court set a hearing for 2 p.m. on October 19th, 2023 to quote, this is my favorite line of all time. Like anytime I'm getting in the argument, the due process argument, and that it didn't exist with respect to the DQ, it's these recent developments. That's her notice of due process to the defendant. These recent developments, that's what's on the record. That is what is on the record. That is what her order, when she set the date for the 19th, that's what it said. These recent developments, not for apparently McClellan in his DQ motion, which was never filed apparently and served upon anybody, but these recent developments. So despite Allen's instructions to the contrary, on October 12th, 2023, the trial court sua sponte ordered. So the day after Allen sends the email to the judge saying, these are my guys. This is who I want as my guys. The trial court sua sponte, again on its own order, or it's on motion, ordered Rosie and Baldwin to, quote, cease work on Mr. Allen's case, end quote, and scheduled an in-chambers meeting for 12:30, October 19th, 2023. Before the hearing scheduled for 2 p.m. That's on record 191. This 12:30 meeting is not noticed anywhere on the CCS. That's what I'm talking about. No, I've been having just like a epic battle with Brett over due process, and he's saying everyone knew, they knew. I'm like, man, that's not how it works. This isn't gotcha. There has to be due process under the law. There has to be proper notice. It has to be filed. Like, in what world are we living in where now we know it was McClelland? It wasn't even sua sponte. Now we know it was McClelland who wanted to DQ him, which I could see why, because he's getting out lawyered. Sorry, but he is. I don't care if you hate Rosie and Baldwin or not. He's getting out lawyering McClelland. That's when a prosecutor's trying to get rid of a lawyer, you could be guaranteed it's for one reason. It's because that lawyer's out lawyering them. Short of them doing something horrific, you know, I mean, but like, for all intents and purposes, again, am I sad that the drip happened and people take exception to me calling it a drip, but that's what it was. I didn't see any of the crime scene photos, and I know one person personally. I don't know Rick Snay, but I do know Kevin and Anya. That's it. I always mispronounce her name. It's Gaelic. It's a beautiful name, but I always butcher it. They saw the stuff. That's it. That's like.
Well, we know other people claiming that they saw the stuff and offering to send it.
Who?
Never mind.
I mean, people have asked us. We've declined respectfully. Hard pass. You know, like, I don't need to see that. I don't want to see it. You know, but like, as far as I'm concerned, it's a contained drip. That's what it was. That does not rise to the level of everybody screaming and throwing their hands up that these guys are monsters. And frankly, I find it offensive that anybody's going to besmirch these two lawyers' character and their fitness in terms of their record in the state of Indiana. They've got zero disciplinary issues ever. For anybody to suggest that they are leaking this improvidently on their own accord, it's disgusting. If I was saying that about if I was going online and saying that about the prosecutor or the judge without any kind of evidence to back it up, I wouldn't do it. I don't know why people think it's okay for them to do it to a defense attorney who, again, that's who represents us, the people, against the government from violating our constitutional protections. Remember that, please. If you're a big pro-government person, still remember that fact. When the government's knocking on your door and you don't want them in your house, you know who you're calling? You ain't calling the county prosecutor. I'll tell you that. You're calling one of us. Prior to this meeting, Baldwin filed a memorandum explaining the circumstances regarding the photographs and the fact that not only was Attorney Baldwin snookered and abused and betrayed by the theft, but more important, nothing, quote, has been disclosed that won't be disclosed at trials or hearings. Now, I've been saying that, which is true. This isn't like something that's not coming out at trial. And the concept, what I was trying to tell people, like, look, this is not advantageous to the defense. It's quite the opposite. We've talked about it on several lives. I would be mortified if these got out, because I would immediately think, oh my God, my guy's the one under arrest. My guy's the one sitting in a prison awaiting trial. And now, because I know how Americans think, they're going to immediately attribute those horrible acts, which are now leaked out to the public, to my client, because there's no one else to attribute them to. That is not a move that a defense attorney is ever making intentionally. I promise you. It's like a death sentence for your case. No attorney would ever do that. No defense attorney would ever do that. To try to bolster their claim of runes. Well, the runes are on top of the girls. You'd be looking at those awful crime scene photos. Like, that theory is ridiculous. It really is. No defense attorney. Oh, well, I want so much people to believe my memo and the runes that I'm going to leak. Come on. No. Wrong. Didn't happen. All right. More important, nothing has been disclosed, blah, 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 blah. Attorney Rosie similarly provided the trial court with a letter outlining what had happened and enclosed the above letter from Allen stating that he still wanted Rosie and Baldwin as his lawyers. During the October 19th, 2023 Chambers meeting, at which Allen was not present, once again, all this is happening without the defendant being there. Due process under the law. Look it up if you don't know what it means. Look it up. It's pretty important in this country. At which Allen was not present, even though he was in the courthouse and his presence had been requested, of course, I'm sure by his attorneys. The trial court read a prepared statement to Rosie and Baldwin, accusing them of gross negligence in their capacity as Allen's counsel. These reported acts of gross negligence are efforts by the defense to level the playing field with a press release after the prosecution filed multiple releases. And I'm so excited this came out because I could not find that thing after it was out. We talked about it. We referenced it the other day. And that was them trying to level the playing field where they said, hey, we read this PCA. We're telling you it's hot garbage. And this is why, and like I say, PCAs come out and the entire world gets to look at them. And then they form their decision based on what amounts to nothing more than the state's theory of the evidence and their theory of the case. That's all it is. It hasn't been vetted at trial. It's the entire purpose of trials. You can't judge whether somebody's guilty until you've had evidence vetted at trial. You don't know what's what. You don't know what's authentic and what's not. I mean, that's why they have trials. If you're going to just start declaring people guilty, then let's get rid of the whole trial system and just live in nightmare world. Filing motions to protect Allen's basic human rights, motion that the trial court either granted or that remains pending. Filing the Franks memorandum that the trial court believed contained improper statements. Allison, now you spoke on this. Do you think that it's within the judge's purview to decide whether or not she likes the defense's theory of the case?
No, I do not.
Okay. That's not the judge's job for her to decide whether or not she likes their theory of the case. She may hate it. You know what? She's got to keep it to herself. Her entire role is to remain objective. Objectivity is absolutely critical when you are sitting on the bench. And I'm going to tell you right now, based on the actions that she's taken in this case, she has lost her objectivity with respect to this case. That's my opinion. And all I can base that on is the things that have been going on in this case. And for everybody out there that wants justice for Abby and Libby, you should be looking at this judge and saying, what are you doing? And it's a problem. And again, hate Baldwin and Rosie all you want. Hate the fact that they were sloppy with the discovery. That's fair. I'm not begrudging you that fact. Notwithstanding that, long before the leak happened, the judge has been butchering this case. That's my opinion. To have substantive motions filed and for her to not even set a hearing date for months is insane. The way you have a briefing, you come in and you say, all right, defense filed a motion. State, how long do you need to respond on this? State says, I need 3 weeks, a month, Your Honor. Got it. I expect, no, not on this one. Scarlett's trying to jump in. So, my daughter, for those of you who don't know. No, but not on this one. Sorry. Come on. This is a serious, sorry. I love her, but I'm not letting her come on today. She's going to slam the door. No, she didn't. All right. So, at that briefing schedule, this, they're saying, look, you got your time. You get your, and she sets dates. State, you got 28 days to respond. I need it in writing. Boom, here it goes. Okay. And then she says, and then she sets a hearing date. That did not happen ever on this case. It's bizarre to me. I just, It's not how a case of this magnitude is handled. I mean, the only thing that I know, after Rosie filed, she then ruled on a bunch of motions and jammed them in a court order. The only thing that I know that she ruled on definitively are denying the original motion to have Alan and housed in a different facility than Westville Prison, and 2, the discovery deadline. I mean, that's it. That's all I know that she's ruled on. And there is a multitude of pending motions in this case, not just from the defense, but by the state as well. All right. And remember, because I keep yapping so much, which I'm prone to do. Sorry about that. But, I'm talking about these are the acts of gross negligence in Judge Gull's perspective that required her to DQ these guys, or that she threatened to DQ them if they didn't withdraw. Filing a tort claim notice to preserve Alan's rights to seek redress from conditions and treatment related to his incarceration. So she's spiting Alan's attorneys for them trying to protect him. That tells you what that tells you. Now, we did this on Garcia too, because they were torturing him in there as well in Douglas County. Same thing, not letting him sleep, tasing him, all this stuff that happens to high profile defendants all the time in cases. It's just people that don't understand and think that jails are some kind of civilized society where people are just walking. Good day, sir. Good day. No, it's not what it's like. It's not what it's like in prison. For people that don't think that guards give these guys massive amounts of shit, you're living in a dream world. Especially when there's child victims. Everyone hates people that they think or that have or have been convicted of harming children. They are public enemy number one by not just the jailers, but the inmates. That's facts. And Richard Allen is housed in the Indiana House of Pain, where the worst of the worst go as a pretrial detainee, because they claim that they can't keep him safe in either Cass or Carroll County Jail. A third party's unauthorized photographing of the crime scene evidence, which neither attorney had knowledge or participated in. So that's her laundry list of things. Filing motions. She's holding against his attorneys for filing motions to protect his basic human rights. I don't know. Am I crazy or is that nuts?
It's nuts.
I mean, that's her laundry list of why you're grossly negligent. After reading this prepared statement, the trial court then informed Rosie and Baldwin that they have 2 choices. 1, you can voluntarily withdraw your appearances immediately, or the trial court will read this prepared statement into the record and then disqualify both attorneys in open court.
Right. That's what I was saying, that they reiterated much of what they wrote in their motion to have the judge removed.
I hear you, but we've got 815 people, which means
no, I'm not saying not to say it. That's what I was getting at earlier when I was like that, so now, like you said, it's of the Supreme Court. So.
Oh, that's a good Frozen shot. You're going to love that one. You're still gorgeous.
Am I unfrozen now?
You are.
Okay.
I gotta get you another booster over there, right? Like, you're closer to the internet than I am. I don't understand it. Okay, so that is what, when they're referring to a Hobson's choice, as you can see by those 2 choices, either a public shaming or, I'll let you get out of the case, which typically is hard to do. It's not impossible by any stretch of the imagination, but you can't just get out of cases when you're the attorney of record, especially after a year. Because remember, the victims' families are sitting here waiting and waiting and waiting for this trial. And they have no idea why things are delayed, Why? Like, it's the number one. I always hear this. What, like, because prosecutors, for whatever reason, just don't tell victims' families exactly what's going on and why things are delayed. I'm not telling them to talk about the facts of the case, but please inform them. I can't go to the victims. I would love to say, I'd love to hug them first. And then I'd say, I want you to understand why this is taking so long, why it's taking 2 to 3 years to get justice, or maybe we don't get justice for your girls because they have the wrong person. But like, I want you to know, I want you to understand fundamentally what is going on here. And for whatever reason, like, these families are just left in the dark. Always. It's heartbreaking. It really is. And I'll never understand why prosecutors just can't take them aside and say, look, this is the process. It's like, it's the same thing. They should just watch my lives and your lives, because I explain the process. The discovery process is lengthy. The motion process is lengthy. It all takes time. You know, that old saying, the wheels of justice turn slowly, is true, because it requires work. We're trying to get it right. We want to do the job right. All right, but I digress. Attorneys Rosie and Baldwin were shocked and asked to meet with Allen before making many decisions. Allen reaffirmed that he did not believe Rosie and Baldwin had engaged in any negligence, much less gross negligence. Allen also reaffirmed his desire to move forward with Rosie and Baldwin, his sole counsel, and objected to the trial court's attempt to strip him of that counsel. After speaking with Allen, Baldwin and Rosie returned to chambers and articulated that they believed the trial court had engaged. This is why we want to hear the audio. This is why we want the transcript. Now we're getting the dirt. This wasn't in the other thing. That they believed the trial court had engaged in unconstitutional ambush of the defense counsel without due process. Record, page 231. Write it down, mark it somewhere, put it in your phone, text, whatever. They informed the trial court that any withdrawal could be involuntary and under duress, because the trial court had made clear that if they did not agree to withdraw, the court would disqualify them in open court. That's a Hobson's choice. That is no choice. You can either go have me pants you, and I'm telling you what the answer is going to be. I'm DQing you.
Hey, sorry.
Attorneys Baldwin and Rosie believe this placed them in an impossible ethical bind. If they did not withdraw in chambers, the trial court would publicly disparage the representations of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's case in a negative light. So true. So true. That's the biggest thing right there. If she pants them in public, where she's putting on the record that she's poo-pooing their theory of defense because she thinks it's nonsense, that destroys the credibility of their theory of defense moving forward. I don't care if the new lawyers like it or not. If they're like, yeah, this is we agree. We've gone through all the discovery. We agree. Well, you can thank the judge for flushing that down the toilet like a giant stinking turd, because he did it publicly. They believe that such a public statement from the trial court, quote, risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation.
What page are you on right now?
11 of 22.
Oh, I'm wondering why, how did they work this into the judge's failure to, docket things and keep the record straight in public access?
I don't know. I mean, maybe they're pulling a Rosie. Woo!
Right.
Sneaking stuff in.
I think it's just to show that she's doing it. I guess it's just to show that the judge is doing it not for legitimate reasons, but for...
Right, that she's gone off the rails. She's lost.
But they are flipping it in a little bit.
Definitely. I mean, but it's pertinent. I mean, I think that they have to, kind of in the same way that they were overbearing with the Odinism stuff, where they had to bring it up to some extent in the memo. I think that they went way overboard. We didn't need 100 pages of it. And 100 pages of it is like an exaggeration. It was a lot of it was about, you know, the 3 alternate suspects or 4 alternate spots or five guys that they thought were all connected to Odinism. But like, I mean, for this, they have to, like, I think it's important for them to give the Indiana Supreme Court the basis by which they're saying that she's pulling this stuff from the record.
Yeah,
right?
and I think they need to, because it going the next thing about why he didn't file his motion to withdraw, and then his notice of intent or notice of continued representation was stricken from the record.
Yeah.
Which they're about to get into.
Okay. Let me see. Okay. Blah, blah, blah. Faced with this dilemma, Attorney Rosie informed the trial court that he would file papers regarding his withdrawal at a later date. And Attorney Baldwin orally made the motion to withdraw. Okay. All right. And like, I'm just going to go through this and then I'll be done with this. Okay. I promise. Okay. So this is ID, bottom 11 of 22. Allen instructs his chosen counsel to make filings on his behalf, and the trial court orders the clerk to remove those filings from both CCS and the electronic case file. Okay. After the events on October 19, 2023, Allen instructed Rosie to file the notice. Okay. We know about that he was still representing him, indicating that Allen did not want him to withdraw his counsel. So sorry, right, Judge. I promise.
Right. That he went and talked to his client about it afterwards. And his client was like, please don't withdraw. I don't want you to withdraw. So he filed his notice of continuing representation.
Right. Okay. The notice informed the trial court that it was, quote, no circumstances under Rule 1.6 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rosie's representation of defendant Allen, which I agree with completely. You know, I mean, I've said it once and I've said it a million times at this point, that even if she's bouncing Baldwin because that happened on his watch, okay.
Right.
But he still has but because like when I walked out of that hearing, we were all wondering, well, okay, we knew, because remember, these are 2 guys that have separate practices. They both have private law firms. They're not in the same firm. They're not partners out in their firm. They're 2 separate attorneys that have 2 separate practices. And there was no allegations whatsoever that Rosie had done anything.
Right.
So when we're walking out, like, you're like, oh, well, maybe it was solidarity. You know, I mean, we were trying to guess, why would Rosie have dropped out? What's going on? Why they bouncing out?
The judge, I was thinking outraged that the judge would boot the lawyer, but
right. I speculated that maybe like Rosie didn't want to stay on because, you know, he was worried that successor counsel was going to hate their defense and that him and the new person would be butting heads and, you know, ultimately he'd have to withdraw. I mean, whatever. We were speculating, but now we know it wasn't any of those things. She said she was going to DQ both of them. And I agree. She may have had grounds for Baldwin. I mean, that's not for me to decide. That would have been within the judge's discretion. Could have been taken up on appeal. But, I mean, I think that there would have been nothing from stopping her at that point. But with Rosie, it's a different story. With Rosie, there were no allegations whatsoever that he had done anything. It didn't happen on his watch. She can't repeat Baldwin's office and the ongoings there onto Rosie. Guy's got to do it.
So that's what he's getting into here. Lets them know that he filed the notice that his client wanted him to file after his client insisted on on him not withdrawing. And then he also, Allen, wanted Rossi to file the motion to recuse the judge. And then they put up what the judge did next. So go ahead.
Where is it? Like I'd happily allow, but you just won't accept the thing from StreamYard. So you can't.
I know I looked for it. It's not there. No, I just mean,
I don't want to be the only one reading this whole thing. like you haven't put yourself where you're like an admin so you can control things on the screen. So it's like, I feel like I won't know where you're reading. You want to read some?
Go to the bottom of page 12 and just show them that basically what they put in next is that the judge saying, none of these people are lawyers. I'm striking everything. Remove it.
Okay. So there it is. So that, you want to read that out? Read that out for the people.
No, you can definitely read that out.
All right. So it says, court notes filings by former attorney Rosie on October 25th, 26th, 2023, and takes no action. Attorney Rosie withdrew from this matter on October 19th, 2023. Oh, did he? Did he? I don't know. I don't think he did. And is no longer considered record. You know what I like to call that? I like to call that revisionist history, where she changes what happened in actuality to fit her narrative. She can't unsay what she said out in the well of the court in that 5 minutes, where he said that, you know, she talked out of both sides of her mouth, though. She said they both withdrawn, but that Baldwin made an oral motion which I granted. That's the magic word. I granted it. Granting is the key word in any kind of like court order type of proceeding. Like you have to, she either grants it or she denies it. And with Rosie, that didn't take place, but she said that they both withdrawn. But then she says, well, but Rosie says he's going to file something in writing. I assume it's going to be in the next few days, and then blah, blah. So it is no longer a counsel record. These filings, therefore, are ordered stricken from the record. So clerk of the court is ordered to remove the pleadings from the electronic case file and the CCS as being filed in error. See, so they brought it all the way back. So they led you into it with all the stuff you were wondering why they snuck it in. And they brought you all the way back because that last paragraph is what this whole writ of mandamus is about. All right. So then they get into, now, did you get into any of the meat? Because you did express some concern off live about whether or not they're going to be able to meet what they need to meet. And I'm talking about these lawyers in terms of getting this stuff all back on the record.
Well, I think that they're going to be able to establish and following the rule. I know when we were first starting to talk about this, I didn't know under what basis they were proceeding. So now that I see it's basically public access, it's a different kind of analysis than what I was initially thinking.
Yeah. I mean, it's not going to the heart of the case. You know, it really is tangential to the case itself, to the underlying facts of the case. It's collateral.
They must think it's so black and white that it's going to make the Supreme Court act. And if the Supreme Court starts to look at this, they're going to lay the hammer down. It is what I presume that the attorneys who filed this believe.
Well, flesh that out for the people. Like, what do you mean?
Well, because of the requirement that a judge, you know, like if a judge is failing to perform their duty, their absolute duty imposed by law, which this is outlining that she is, even by stressing that there's a requirement that things become public. You have to, you know, file I wasn't paying attention to what it was called, but whatever you need to file, if you're going to seal it, it has to be available on the record in the spot where the document would otherwise be. You know, that it's that there's some things that they think that the court's going to see as black and white. The judge is not doing what she's supposed to do, and then going to kind of look at the big picture and down. Where coming at this another way, the Supreme Court might have said, you know, this is not our purview right now.
Right. Yeah, like I agree. I think it's an absolute backdoor move that's going to get, it's going to get them the Supreme Court thinking DQ. You know what I mean? Because it's like you got these kind of black and white issues that are like she clearly violated the Indiana Supreme Court rules with respect to handling of the docket, and the hope,
I mean,
I
the
think,
worst case, they'll say you've got to put all this stuff up on the docket, make it all public.
right.
Nothing else happens.
But to your bigger point, I think that it might get them, because that's what I'm saying. That's why I think that they added that kind of stuff, because if she's lost her objectivity, she can't be on the case anymore.
Right.
And you're muted, so, I mean, she can't be. Like, I mean, it's the number one rule for a judge is to be objective. You can't be subjective. And I fear.
I'm surprised they didn't comment on the fact that she entered that order, and unlike all the other orders where notice goes out the same day, notice went out 5 days, 6 days later.
Yeah.
I guess they're trying to not, I guess.
All right. So, like, these are a few of the things I want to look at. All right. So these are the emails.
That's attached to the exhibit, to the motion.
This is attached to the record of proceedings. That's what I'm saying. They're
I thought that I pulled that up. I couldn't find it.
I told you it was in the record of proceedings. It's got all the tea. It's got all the receipts, all the stuff that she didn't want out there. Like, the bigger part of this is that, and again, this is not Baldwin. This is not Rosie. This is not Hennessy. This is not the new attorneys. These are three attorneys, three Indiana attorneys that were so disgusted by what they're seeing, because everyone kept screaming and yelling, "What can we do? What can we do?" This is what you could do.
Yeah, I don't see that on the docket as being something that I can actually click on and view.
Wait, what docket?
The Supreme Court's docket.
Are you seeing the writ of mandamus and the?
Yeah, I clicked on that. I clicked on the order. I clicked on the writ of mandamus, the brief.
I don't know, but Yellow Jacket got it to me, so it was out there somewhere. I'm telling you, Yellow Jacket, Delphi Docs, Sleuthy. I got mad people out there that are incredibly skilled.
All right, so now I want to see it. So stick it back up, or is it up? I was trying to look. I can't read that.
You can't read it? How about now? Is it better? You can
sure.
read that. I mean, it's huge for me, for my blind ass. Like, I could see it. Do you want to read it? So, this is. Do you want to read it, or you want me to read it?
No, I definitely don't want to read it. I can barely see it.
All right. So, Francis Gull, from the judge, October 12th, 2023, bright and early, 6:59 a.m. Gentlemen, this is beyond tragic. Once again, I'm at a loss for words. I'm deeply concerned that Mr. Allen's defense is being compromised by all these recent events. Are you?
Maybe he is. I don't know.
How is
I don't know.
Podcasters or YouTubers seeing crime scene photos compromising his defense?
She might have been genuinely worried that was going to get released to the public, and his entire
even if they did, disgusting. No question.
Right. Well, it would hurt his defense because, like we said, nobody wants gruesome pictures of the victims out there that are going to make people.
That's a legit point. All right, so I am deeply concerned that Mr. Allen's defense is being compromised by all these recent events. I will have my staff schedule a hearing in Fort Wayne for next Thursday, October 19th, 2023 at 2 p.m. to discuss these recent developments and the upcoming hearing on October 31st. I will have a transport order prepared to get Mr. Allen to the hearing. Please arrange your schedules accordingly and appear in the Allen Superior Court. Mr. Rosie and Mr. Baldwin, please cease work on Mr. Allen's case until we meet on the 19th.
Come on, slow down. You're keeping us waiting here.
Oh, sorry. Nick McClellan then responds. Whoa. This is actually, so this is.
Yeah, we got it. Read it to us.
Wait, but they're, what?
Oh, they're not in order.
Right. All right, so McClellan, first, he emails on, because this one came out 6:59 a.m. So McClellan first emails at 4:07:48 a.m. to Judge Gull, to Rosie Baldwin. They're all CC'd on it. Caution. This email originated from outside your organization. Exercise caution when opening attachments or clicking links, especially from unknown senders. Judge and gentlemen.
Thanks for that part, babe.
What?
Thanks for that part.
I mean, maybe he stuck that on there just to show he's super cautious. I'm really cautious.
That's coded on every U.S. State's attorney's email.
Is it really?
Something to that effect. There's something like that on ours.
Oh, right.
Go ahead. Sorry, read it.
Judge and gentlemen, it is currently 3:53 a.m. and I just got off the phone with Indiana State Police. From the phone conference that the four of us had on Tuesday afternoon, October 10th, Andy Baldwin informed us that Mitch Westerman went into his conference room sometime in August and took pictures of evidence in the case and then leaked or forwarded those pictures to an individual by the name of Robert Fortson. Robert Fortson then leaked or forwarded them on down the chain, and eventually it was made public that the documents were leaked. Robert Fortson lives in Fishers, Indiana, and is employed as a civilian Title 32 technician at the Fort Wayne U.S. Air Force Base. As part of the investigation, an ISP detective went to the Air Force Base in Fort Wayne to interview Robert Fortson on Tuesday afternoon to get a statement from him about the leaked information. The goal was, one, to gather the photos that he had to make sure that they were deleted from his phone, and two, find out who gave him the photos and who he gave the photos to. Robert Fortson met with Indiana State Police detective, but refused to answer any of the questions and stated that he wanted an attorney. Soon after, we had our phone conference between the four of us. At 10 p.m. last night, Robert Fortson committed suicide. One self-inflicted gunshot wound.
Roll for us.
I am.
We can't. Oh, I can't see. I can't see after Robert Fortson. I don't know if
I think
anyone
you should
else.
log off and log back on. You're freezing.
Oh.
I think I'm scrolling as I'm reading. So I think your face is frozen right now.
All right.
You still look beautiful though. All right. So one self-inflicted gunshot wound. He is married and has a teenage daughter. The initial information that I have is that his wife stated that he was worried sick about being in the situation. And that the last info that I have is that Robert stated to his wife that if I just be honest or come clean about the photos, I will be okay. That's weird.
Yeah.
That's nefarious. So I have stated, the last info that I have is that Robert stated to his wife that if I just be honest or come clean where I got the photos, I'll be okay. Man, that worries me, like in a different type of way.
Is that the end? What else to say?
Did you log off and log back on?
It just did that. It like rebooted. I don't know. Without me doing anything.
Yeah, but you didn't go out of the room, like off the stage. All right, whatever. I just don't want you to freeze. All right, so I'm not sure if this is the appropriate way to notify everybody of this, but it is 4 a.m. and this is the latest bizarre twist in the case. This is getting serious and way out of control, gentlemen. If you have additional information about this leak, please forward it to me or ISP Detective Holman immediately. I do not want to get another phone call like this that Mitch or someone else involved in this leak has hurt themselves or someone else.
Oh, get the cell phone number off.
Oh, no. Sorry.
Jesus. Now how are you going to fix that? It's rewindable.
I know.
He told you.
I know. I didn't see it. I wasn't even looking at it. I was reading above lines. All right. No one called Nick McClellan. No one. All right. I mean, frankly, anybody on the internet can get this document, I think.
Right.
Okay. Good morning, gentlemen. Thank you for passing this troubling information along to me. I'm quite disturbed by this new development. Since Nick has been made aware of this information, I'm making some assumptions that I would like a response to. One, I assume that the law enforcement is investigating. Well, she was told as such. Two, I assume that the local contact.
Well, this is before, so this is after she first finds out on October 8th.
So this is oh, okay, yeah. So this is like I went backwards.
Right.
So all right, so
I'm
this is
assuming right before
precedes.
this will be the email from Rossi or Baldwin letting her know.
Okay, so yeah, let's go to that and then we'll go to hers since I'm doing it in backwards order. Okay.
Don't read the caution this time.
Huh?
Skip the caution.
Okay. Caution. I'm kidding. Good afternoon, Judge Andy. I want to touch base with you before the end of the work week. This issue revolves around the possibility that some of the crime scene photos have been leaked, so to speak, and are in the hands of the public. There's most certainly a photo of the F tree that is floating around in public. The photo itself is not overly disturbing, but the concept that it is in the hands of the public is of a concern. Of greater concern is the fact that a local content creator by the name of Rick Snay has apparently communicated to the public that he has copies of the crime scene photos. I'm attaching a copy of the communication that was forwarded to one of our staff members by an uninvolved third party. We just learned of this in the last hour. I immediately called Nick and informed him of the circumstance. Turns out Nick has known about this for the past 24 to 30 hours or so. He informed me that they were looking into the matter. Interesting. The primary purpose of this email is to communicate our concerns with the situation. That's interesting to me that Nick knew.
Well, I think it was because, I mean, there's just some timeline I have that was when
murder sheet.
Right.
Right.
They knew from the 5th.
Yeah, I thought the murder sheet had said that they had told McClellan and Baldwin and Rosie, but I don't know. The primary purpose of this email is to communicate our concerns with the situation. We most certainly did not leak this information. We want to make sure that we got out ahead of this and inform the court, as well as Nick, in the event that these pictures found their way onto the internet. This might be a circumstance which requires the court's attention. Duh. I say that in terms of conducting some inquiry into the source of the information leak. Otherwise, Andy and I are both available for a phone call if necessary. Nick informed me earlier that he too is available for a phone call throughout the weekend if necessary. We wait your response. And so this is Gull's response. So this is where we get, I assume that law enforcement is investigating. I assume that the local contact, she means content creator, Rick Snay, has been interviewed. I assume the individual's name Ain, and how do you think that is? Annie and I'll never get it. I hear it and then I forget it. It's weird. And Kevin have been interviewed. I assume that law enforcement has demanded the return of the photographs in the possession of Rick Snay, Ain and Kevin. And then I assume that Brad and Andy have provided the name of their staff member and the uninvolved third party to Nick for interview by law enforcement. I recall our communication back in December of 2022 regarding an email from Andy to Brad, which contained discovery information, but was sent to the wrong Brad in Andy's address book. Has that individual been interviewed? Could that be the source of the leak? I'm also recalling a bill I received from Brad and Andy for duplication of exhibits by a vendor, which I disallowed. Is it possible that this vendor is involved? Brad and Andy should share the name of that vendor and the date that the vendor was hired to Nick and or law enforcement for investigation as a possible source of the leak. Okay. These local content creators are not journalists and have no right to claim any type of privilege. They should divulge to law enforcement who they got the photographs from to allow law enforcement to continue to investigate. The photographs must be returned to law enforcement. If they refuse to turn them over voluntarily, I will issue an order directing the immediate return, and they will be subject to contempt of court. Interesting. The contempt will result in an immediate arrest and incarceration until such time as the photographs are returned. This is a drastic measure I should not have to take, but will if necessary. Each of you have numerous staff and assistants helping you with your work. I am also assuming that you trust those individuals to maintain the integrity of the case and that you are confident that none of those individuals are involved. Please let me know at your earliest convenience what your thoughts are about moving forward. So that's pretty interesting. It's pretty interesting. Oh, I keep showing Nick's cell by accident. Okay. So this is interesting because of the timing of it. Now, I'm not going to go speculating on a whole bunch of things, but, Gull learns about at 4 a.m, October 8th, that this guy killed himself. And I mean, it's after that, we get the kind of her email on the 12th where she's like, look, I'm stopping you all from working on the case. I mean, it seems that's as a result of the news that she just got about, I mean, she must have been stewing on this, all right, so let's see what else we got. Exhibit J. Okay. All right, so this is Alan's. Read that. Exhibit K.
So I just want to say that, my thought that I wanted the judge to be outraged for the protection of Alan, completely dismissed by what she wrote in that prepared statement, like all her actual complaints.
Right. I mean, she was, I'm not gonna lie, dude. Like my brain is kind of like, I've had a lot of questions about the suicide, but I'm shook after I read that, where the last thing he heard is that this dude's like, if I just come clean, I'm going to be all right, which he would have. They're not going to, what are they going to do? I mean,
right.
I'm worried about that.
I mean, he could have just been saying that they said, if you just tell us who you got it from, we're not going to, I don't know what they would do to him anyway. I don't know what crime it is they're trying to flaunt around here.
That's precisely my point. But what I'm more disturbed by is that I've now read that the last thing that McClellan heard from him or his wife, which has to be his wife, is that he was saying that as long as I come clean, I'm going to be okay. That shows what his mindset was.
Right.
That does not sound suicidal to me. Is it like committing suicide because somebody sent you?
It's preposterous, to tell you the truth.
It's scary, is what it is. I hope there's an actual investigation into this suicide, because I think it's warranted. If for nothing more than that,
knows more. I mean, we don't know anything.
We don't know anything more. I don't know anything about it, but I want to.
All right. And then eventually you've got to get over to the start and read the paying comments over here.
Yeah. All right. I'm just going to whip through these. That's Hennessy. These are the filings that we've gone through on other lives. Y'all can check those out, and you should. They're informative for certain. This is the safekeeping order. This is when they tried to get him moved from Westville the first time. Denied. Okay, and I think we're getting close to it. I just want to make sure there's nothing fascinating that we're missing, because I did not get a chance to go through this. All right. Okay, boop, boop. N, motion to DQ. We went through that on a live a couple days ago. All right. I think we're getting down to it. Okay. Continued rep. All right. I think that's it. It'll be the last one. I just have to make okay. Okay, this is did we read this one? Oh, okay. This one I did not read for some reason. Did you see this one? Oh, she's gone. Okay, motion for continuous. Come now, the defendant, Richard M. Allen, by counsel Brad Rosie, and respectfully request this court continue. So they asked for a continuance, October 31st, 2023. This is another one of the things that she had blasted off the docket. For some reason, I missed this one. For the hearing set in this cause. In support of said motion, defendant Allen states as follows. Counsel for defendant Allen is unable to locate any specific order wherein the court scheduled the initial October. That's so great. I couldn't when I kept hearing about this 31st October, this the second time that she's held court on Halloween, the second year in a row. If you'll remember last Halloween when we were in Louisville, I made the drive to Delphi, went to the hearing, and then drove to trick or treat with our daughter. And so she did it again. And so like we did not read this order. So I'm going to read it and then we'll be done with this stuff. So counsel for the, but I kept thinking, I'm looking through the document. I'm like, where did this October 31st court date come from? Like it just appeared out of thin air as if it had always like
it was that email she said.
That's not a court order.
Well, correct, but she wrote an email like we're gonna be in court on that day. I mean that's
but said like but not pursuant to order. There's no court order. All right, I'm gonna read this because he's getting into like I'm just saying I was asking the same questions. Like, where did this date come from? Like it's typically a judge says, okay, next date is gonna be blah blah. Like at the end of a hearing. And in June, she didn't set like the last time I was there prior to when everything like exploded, I didn't hear of it. All right, so counsel for defendant Allen is unable to locate any specific order wherein the court scheduled for the initial October 31st, 2023 hearing date, nor is there any order which articulates exactly what matters were to be addressed and how much time was to be set aside to address said matters. However, counsel does acknowledge that there have been discussed, this is you, have been discussions between the court and lawyers regarding the October 31st, 2023 hearing date and the possibility of the court conducting hearing on the pending suppression motions filed by defendant Allen. I was excited about that. On September 18th, 2023, defendant Allen filed his Frank's motion. Court has yet to issue a ruling on that said motion. On October 2nd, they filed a supplemental motion for a Frank's hearing. The court has yet to issue a ruling on said supplemental motion. On October 3rd, 2023, filed an additional Frank's notice. Court has yet to issue a ruling on the issues raised in said notice. On the 14th, this court ordered defendant Allen's defense team to cease working on all of his work. Okay, and then prohibited counsel from engaging in preparation for October 31st suppression hearing or any other matters associated with the case. And then on the 19th, the court engaged in actions which resulted in the court ordering the oral withdrawal of Attorney Baldwin from the case. Attorney Rosie remains the only active attorney of record in this case.
We actually did go over this last time.
No, I don't think so.
Maybe it was when you left.
Why did you keep going on live after I left?
Remember you were trying to figure out how to.
Oh, okay.
Essentially, he's just asking. I didn't see any exhibits. He was asking for a continuance.
Yeah. Right. I had not read it. So for my own edification.
Until after they rule on the disqualifying motion for her.
Yeah. Well, I hadn't read it, so I wanted to read it. Sorry for the repeat for y'all that saw it already.
No, I don't think anybody saw it because I think I can't put things up.
Yeah. All right. Okay. All right. So there's all that good stuff. Let me try to find, let me get down here. I think I've got, I can't remember. Yeah, see, this thing is like, I had asked somebody to email. Do you have that order? The actual court order?
Which one?
I
saved it.
The one issued by the Supreme Court today.
Oh, no. Yeah. Well, I have it from the doc. Yeah. What do you want me to just read it?
Yeah, just read it out.
Okay. Any brief supposing, oh, now it's opening up because I did it like that. Has filed a verified petition for writ of mandamus and prohibition seeking relief under the rules governing original actions. Any briefs opposing issuance of the writ or any supplemental records must be filed directly with the clerk of the Supreme Court on or before Thursday, November 9th. Any supplemental record must be submitted in the same format required for the record under the original action rule, whatever. And once the briefing is complete, the court will take the matter under advisement.
Okay. All
so
right.
this will move a lot faster than what we're all used to seeing in the lower courts. They're going to, they gave them till the 9th, and then they'll dig in, and I'm pretty sure they'll have an answer within a week.
I mean, in terms of the issues presented, they're pretty straightforward. You know, I mean, clearly she's been violating technical rules. You know, I mean, like the real question is going to be, what's the end result of it? You know, is she? Are they gonna do what you suggest maybe, and like, maybe we need to take a look at this thing. This thing seems to be off the rails. I mean, I guess we'll find out. All right, so for all intents and purposes, in terms of what we're going to end up putting on the podcast, that's it. But now we got to give love to everybody. So if you don't want to hear the love and hear us answer questions, now's the time to bail, because we are most certainly going to give love to everybody that has been graciously donating money to us. So $5 holla from the Unraveling. Boom. We love you. Tina, thank you so much for the $5 holla. $2 holla for Buried in Oklahoma. Tiffany, is that I think that's Tiffany. I keep saying that every time, but I just think it is. Second Hook, YouTube member. Thank you. Thank you so much. Snarky Sass Angel. Richard Allen has a right to be treated fairly and innocent until proven guilty. We agree. Completely. Yes, obviously. And thank you for that $5 holla. Alicia, thank you for joining. We appreciate you so much. Charmaine,
back in action again, Charmaine.
Charmaine's amazing, and Charmaine's a content creator too, y'all. So thank you so much, Charmaine. I appreciate that. Mama, I love that. Or Mama? It's either Mama or Mama. I want to say it's Mama. Which I love. I love it. It's Mama and Papa. Libra scales. I love it. Thank you for becoming a member. We appreciate it more than you know. Kate, thank you so much for the $4 holla. Shiloh, new member. Woot, woot. We love that. Thank you so much. Oh, good. Sleuthy wrote something up. Thank you. $20 holla. Keywords. Read it, babe. I've been yapping the entire time.
Sitting in prison awaiting trial. Make it make sense. How is this normal? A man awaiting trial is sitting in prison. How is this okay? How is this fair? How is this constitutional? All very good questions.
Sleuthy investigate or sleuths investigate? That's an amazing question. And as Allison said, right on point. All right, Sylvia, $10 holla. Thank you. Predictions, by the way, enjoying the channel. Well, thank you very much. We're enjoying that you're watching it. Just discovered it last week. Well, I mean, we're pretty new to the game. Oh, Sleuth investigates again with another $10 holla. Read it, Allie. Oh, she's frozen.
Allen's facing the death penalty case in Indiana. Let that sink in. And his attorneys know that they're fighting the good fight. The dog's even getting worked up over that.
I mean, he's very upset that Richard Allen's in prison. Sorry, folks. Can you mute down there? All right. Where's Shelly? Dash Erica. $2 holla. Thank you very much. Pork chop bean sauce. $5 holla. Justice for Jesse Snyder. Tell me more about it.
Yeah,
let me know what that's all about. It sounds like something we need to know about for certain. I'm always down with justice for people. JD, $10 holla. JD is a repeat offender of awesomeness. I just know that that's facts.
True.
Read it out.
Thanks for being so dependable and hopping on again today to explain it to us. Love you both. Well, thanks, JD.
We love you back. Debbie Jung, another repeat offender. Thank you so much for that $4.99 holla. $5 holla. All right. And looks like our last tasty little treat here is
someone paying to help us out.
Yeah, $2 holla from Precocent, I want to say it is. I love it. I love it. Yes.
Or he or she gives great advice there. Hit that thumbs up button for the models.
And subscribe to the channel, y'all. You'll get the notification. Because I will drop a live on a dime. I will many times not give you any notice.
Here we've got a question from, is it I don't want to mispronounce the name. You go for it.
I don't know where it's at, babe.
It's under the starred. It's right.
Oh, did it just come in? Oh, okay.
Yeah.
Oh, that's Cassia. $5 holla. This doesn't resolve.
Oh, sorry. Go ahead. No.
Please, God.
All right. This doesn't resolve if Baldwin and Rossi are still his attorneys or not. That is very true. How does that part get resolved? That when Bob initially told me that there was a filing to the appellate court, I was like, they didn't even file. Like, I thought they skipped a step if they were planning on trying to file about their removal. I don't know. I think the only way that it gets resolved is if they, what we've been saying a couple times here, file their own appearance, even if it's a limited appearance, for the purposes of getting that addressed and asserting his, I guess, more firmly asserting his demand that they remain as counsel. And then if they do that, the court will have to remove them and disqualify them, like officially under the rules, make like a ruling, say why and how, and then Alan can appeal that. That should be, I didn't double check Indiana rules, but I can't imagine that the denial of counsel is not immediately appealable to the Supreme Court, because typically in a criminal case, you've got to wait to the end. They want to wait and see, because if you win, then there's no reason to bog down the docket with your appeal.
Yes.
You must check out Jesse Snyder's case. So much corruption in Indiana.
Yes,
we will have to do that now.
Yeah, we will definitely have to do it. Okay, let's see.
I think I got to take Scout to softball.
You do? Oh, okay. All right. I'll wrap it up here. Appreciate that, my King of Kings. All right. So, like, I'm going to go through, see if we got any members. This guy, I always have to show him. So, again, like our graphics, like our thumbnails, all the graphics you see on screen, this cat right here, Stevie Irwin, he is my boy. The guy is brilliant. And I give him zero notice. I give him about as much notice as I give you all that I'm doing a live. So, Stevie, thank you so much for what you do, brother. It's beyond appreciated. Beyond. And one of my lovely and wonderful human beings and one of my mods, Mandy, follow what she says. You know, share, y'all. And listen, if you haven't listened to the podcast, do it. It's a great pod. We give you a lot of, like, what you're seeing here is what you get on the pod, except it's probably more refined on the pod. And for those of our podcast listeners that aren't YouTubers, we are converting these. So moving forward, just so you all know, like if we're doing a longer live and we have questions building up, please know that we will always acknowledge, we will always answer for those of you that are members or have done a super sticker, always. But we're going to do it in the middle, because like we have to have continuity for the podcast. I don't want it to be where I'm answering questions in the middle, because we are turning these into podcast episodes as well for our listeners out there that don't YouTube, and there are plenty of them that don't do it. So moving forward, that'll be the way we do it. So we'll do one in the middle and then we'll do one at the end. This one, I just decided to do at the end, but moving forward, that'll be the new move. But yeah, follow on everything. Like my Twitters or X, whatever they call it, is pretty on fire. I think I'm like 80 away on my Twitter account from 10,000, which is a pretty cool landmark. So that would be awesome if you guys can get me there. And I put some pretty decent content on there, and I can argue with people. Oh, Sleuthy's telling me how to pronounce Mamaw. Okay, thank you. Let me see. Okay, wait, I think I got one more in here. Oh, thank you so much. See, look at that. First $2 holla, and then you became a member. Hugs and kisses to you for certain. All right, let me see. Trying to see. I have a question, because I am completely pretty useless on YouTube. Can you guys like put questions up for me, or am I the only one who can do that? Like, if you guys see if my mods can do that and you see good questions, yes, ma'am. I am picking up what you are putting down, Sleuthy. I am picking up. Laura, and we really, really appreciate every single one of you that has taken time out of your busy day to hang with us. Hopefully we're making it informative, and hopefully I'm not screaming so much. Like, somebody was complaining that I scream, like I'm loud. I'm a loud guy. Like, that's never going to change. If I'm too loud, probably just turn your volume down. I probably won't be as loud then. But like, when I get worked up, I'm Italian. You know, I'm like an emotional guy. I get loud. I get excited about things. And when I'm passionate about something, I'm passionate. And I'm not going to apologize for it. Okay. Who's that? Here, give me a kiss.
The car isn't here.
Oh, no. I forgot. Oh, that's trouble. I forgot. We're all right. We'll have Mom figure it out.
She's not doing anything.
What do you mean?
She's not doing anything.
All right. Well, I'm on a live with like 800 people. So we'll figure it out. I'm about wrapping it up anyway. All right. I love you. Wow. What a ham. What a ham. All right. Let's see. Boop, 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 boop. I'm going through.
Comment about me.
People love you. You're the
Wait,
best.
I can't see my finger. Oh.
Okay. All right. So other money or politics equals same thing. Agreed. Covering up, higher up arses, etc., which was about Abby and Libby. Here to that. I mean, it seems to be really getting lost in the mix. It does. It's like, it's scary on a lot of different levels, because we cannot forget that this is about those two girls. And it's like, we're getting so far afoot that it's scary. I mean, it's a lot. Okay. Let me see. Okay. There's so many, like I feel bad that I'm going to probably miss some questions just because I don't want to keep you guys while I'm scrolling, but there's so much. If anybody has a great question, how about this? That I did not get to, how about you drop it down at the bottom so I can see it now and I'm not boring the hell out of you guys while I'm scrolling. Okay. I think mods can star chat comments for you. Maybe you need to have permissions on either YouTube or StreamYard. Maybe. I don't know. I think you're right. Let me see. Let me check on YouTube real quick and just see what's up. On YouTube real quick. Okay. Just see what's up. Yeah, I can't tell on YouTube. I could just, there's no way. All right, y'all. So let's see, there's one more that popped in. Okay. $5 holla from Sluice Investigates. Riddle me this. When is Bill coming stateside for Gacy? Because I'm here for it. Ooh, that is an excellent question. I hope soon. I'm assuming that Bill Dorsch is going to come in when I get this dig all worked out. So you better be here, because I'm going to I need a former cop with me to have my back in case things get sticky. But they shouldn't, you know, but Shane, even though I typically don't put questions from non-subscribers or, well, non-members at least, well, because it's public record that he's 5'4". He's small. I've seen him in person many times. He's shockingly small if you're talking about Richard Allen, which I'm assuming that you are. Okay. Does the Indiana AG have the authority to have Rick Allen moved? Yeah, but he's spoken on it. Like I just saw after the original motion that was filed by the defense, he basically came out and said that he's got competent, good attorneys prosecuting the case. I mean, he's the head prosecutor. He's not going to be siding with the defense anytime soon. So like in a lot of states, there's something called an ombudsman. and the ombudsman is the one. If you think there's civil rights violations or things of that nature going on, like you can make a complaint to them and they'll investigate it, and then they can sometimes facilitate the move. I don't know if that's the case in Indiana. I can't speak to that, but I know that in several states, including Nebraska, where I was desperately trying to get Garcia moved too, and had no luck with that. And then you saw, if you know anything about that case, and you saw what they rolled him out looking like, asleep in his chair, tranquilized, looking like the Unabomber, like sleeping through his death penalty trial. It was insane. All right, Travis, like you seriously need to become a member. Like, I don't know why you're not a member already, because you're smart and I like your questions. And like, if Allison was on here, she wouldn't let me put it up, dude. I'm just telling you. One question someone asked before the stream started: Kid, Indiana subcourt, I assume that's Supreme Court, just ignore this. No, hear it. I think the order answers this for Bob. And yeah. So they can basically get to the point where they can say, all right, look, I don't know why it's here. I mean, they're not going to ignore it. And they didn't ignore it. They gave a requirement to McLeland to answer, or not McLeland, but rather the judge. The judge has to answer in the county. So the county has to get their attorney to answer. The county attorney's going to have to answer on behalf of them. And Gull is either going to have to answer on her own or get a lawyer, which is interesting. So they both have to answer. So we'll see. Like, that'll be great. I can't wait to read Judge Gull's her response, that pleading. But ultimately, like when we filed what they call an interlocutory appeal on Garcia, which was in kind of the middle of the case, it got shut down, and it was basically on a technical rule. That's why we were talking about probably about midway through this live that I think that they tried to address that particular issue that they anticipate that the Supreme Court of Indiana may raise, that technically they don't have the grounds to argue it because there hasn't been an original action, meaning that there hasn't been an order or something happened that caused them to bring it up to that level. So, we'll see how it plays out. All right, Megan Z, $20 holla. Thank you so much. Watching at 2x speed and trying to catch up. It's intense. How much do we have to crowdsource for you to join Rosie and give this man his rights? Number one, have it on good authority from multiple people that you cannot use any kind of crowdfunding to put money together, at least like, the known crowdfunding apps. You can't use those to raise funds for a criminal defense. So if we're going to do that, we're going to have to try to figure out an alternate way. And let's see, this can happen to anyone if no one is held accountable. Due process always. Here, Megan Z. Here. Carrie H. Very close. It's just no E at the end. Otherwise, you spelled it correctly. All right. Let me see if there's any other stars I'm missing. Okay. AKA Radar, $5 holla. Thank you once again for supporting us. Bless you both for taking your precious time to educate us lay people. I like to say lay people these days on what's up. Get a Dunkin' coffee. They blow Starbucks away. I got my own machine. I make my own cold brews. I'm like a cold brew addict. I drink a lot of that stuff, probably too much. That's why I always feel jittery. All right. So listen, y'all, I adore you. Thank you for everyone who came in. If you haven't, please subscribe to the channel. We will always give you good content. We may not always agree, and that's okay. I love having people that don't agree, and I love having them comment, and I will never ignore comments that aren't in agreement with things that I'm saying. I'm an attorney. I argue for a living. I encourage spirited debate. I really do. I want you guys to know that this isn't like me just stumping for defense lawyers. It's not my thing. I'm very objective. And if I think the defense attorneys are screwing up, believe me, I will call them on it. And if I think the prosecutors are screwing up, believe me, I will call them on it. If I think the judge is screwing up, believe me, I will call them on it. You know, I mean, I'm just giving you my opinion. And that's all it is. And you can take it for what it's worth. When I'm giving you just facts, those are the facts. When I'm giving my opinion, it's nothing more than that. That's it. And you know, like I truly encourage engagement from every side, whether you agree with me or you don't. Like, this is not some one-sided thing here, because I really want everyone to feel inclusive. And, you know, I mean, look, my position on this thing, and I've made it clear. And, you know, I just want you all to know that, you know, I'm here for everybody. You know, like I do have opinions on this case. I happen to think that they have the wrong man in custody, which for Abby and Libby and their families terrifies the hell out of me. Like, frankly, I mean, it just does. Like, I read too much in the memo. When you strip away all the Odinism stuff and you just look at certain things that were done and said, I am extremely concerned about the investigation. Okay. And I've read lawsuits by certain members of law enforcement that used to work for Carroll County, wherein they were concerned about the investigation and the people that have been handling it. So, I mean, there's a right to be concerned. So, you know, and I know that everybody, the one thing that we all agree on is that we all want justice for Abby and Libby, because that is the key to this entire thing. And at this point, we all have to be extremely nervous that that's happening, for a multitude of reasons, not just whether or not I think that they have the right guy. Because if they do have the right guy, this is turning into a mess. This is turning, if they have some stronger evidence than what they've presented to us thus far that really can nail down that Richard Allen's the guy, then we are staring at a nightmare at the appellate level. I'm just telling you right now, it's a problem. This is all a problem. And it's not as clear cut. And, you know, I've got friends on the other side of the aisle that disagree with me vehemently on certain things. But, you know, the one thing that I'm going to tell you is that this due process issue, you know, and this Sixth Amendment right to counsel, which, you know, the Supreme Court has acknowledged that, you know, and I was talking earlier, if you're late to the stream, that, you know, there's this issue where people that are appointed counsel, that they don't really have the ability to argue that they have the right to their chosen counsel because the lawyer was appointed because they're indigent, because they didn't have the money to hire a lawyer. And I was saying that I think that that's inequitable. I don't think that your ability to choose your lawyer. So, and they call it the continuity of the attorney-client relationship. And there's definitely that exists. And it can't be argued anymore by anybody that Richard Allen doesn't want these guys, or the people saying what they think is in Richard Allen's best interest, because it's not my decision to make. And it's no one's decision out there for y'all to make. It's his decision and his decision alone. And these are the guys he wants. And frankly, love them or hate them, you cannot deny. And I can tell you how much work goes into these types of pleadings and how much they're putting into this defense. I have zero doubt that both of these lawyers who are fighting like hell to stay on this case, and right now are not getting paid a dime for any of it, to stay on this case, they believe he's innocent. And that means something to me, because you know what? Aside from the prosecution and law enforcement, you know who else has seen all the discovery in this case? Those guys. And, you know, it speaks volumes when you have defense attorneys that had an out. There's no question about it. They had an out. And, you know, they know that Richard Allen has made these confessions that are recorded. They're not denying they exist. And they are not getting out of the case. They don't want out of the case. Like, if you have a defense attorney that's saying, man, like, I can't leave this guy like this, it should say something to you. It really should, because it tells you a lot. It really does. It says it without saying it. You know, tell me that you think he's innocent without saying it, but they have said it on a multitude of times. You know, and defense lawyers are always saying that my client's innocent. I mean, Rex Heuermann's guys saying that, like Ann Taylor saying about the Idaho 4K. I mean, it's par for the course to a certain extent, but when you get to this level where you have this kind of stuff going on, where you have a judge just hammering away on these guys, because everything's out there now. Everything that these guys, like, you cannot make the argument that these guys are just like, they were afraid of soiling their reputation, and that's why they withdrew. I mean, because it's all out there now. All the dirty laundry, like everything that went back in chambers for the most part. And we're going to get to hear at some point these transcripts because they're going to be made public. What went back on chambers on October 19th, we're seeing it. We know what the judge was going to read. We know what she was going to say, if she was going to pants him and DQ him. So it's out there. Yet these still want to be in the case. I'm just telling you, it means something. Like that should not be lost. And like, for people saying that what's in Richard Allen's best interest, again, it's not your decision to make. It's the guy whose life is on the line, and he has the conversations with his lawyer and talks to them all the time, and they tell him what they're doing and what they think of the case and what they like. I mean, no one has. I don't have the ability to say, because Richard Allen is the only one who knows what his attorneys have been doing and how hard they've been working. Because all we know is what is at the, what has been filed and what Gull's allowed us to see. So, all right, y'all. I am going to be on Vinny tonight. I think we're talking Adelson. So I won't be talking Delphi unless I can convince Vinny otherwise. But there was some crazy stuff going on in that Adelson case today too. And my buddy at the Shaming of Jay streams that trial daily. So if y'all aren't watching Jay, you need to be watching Jay, because that trial is lit. It's crazy. It's got everything. It's got all the stuff. So make sure that you're checking out the Shaming of Jay and his YouTube channel. Also, my boy Joe Jackalone, former NYPD, longtime guy. He's got the finger on the pulse of everything Gilgo. And my boys at Publicly Buzzed, they got the finger on the pulse of everything. So they're digging into everything. They put together amazing content. So give love to all my homies, my deep homies. And thank you guys so much for hanging for so long. I know I'm going 231. It's a long one. You guys are champions, absolute champions. And before you go, like, subscribe, share. It means everything to the channel. If you all want me to keep doing this, you got to get the word out. I think that we're giving you some pretty good information. Both of us know what we're talking about, Allie and I, and we love y'all. All right. Peace. Just facts.